All right, ladies and gentlemen, if you'll take your seats, I'm going to call this meeting to order of the House Public Safety and Homeland Security Committee meeting. We've got a number of members that are online and joining us on Zoom. I want to remind them at this time that if you will check your House email account, those who are online, if you'll check your House email account, you should get some information about the meeting in your House email account. So at this time, I'm going to ask Mac Jackson if he would open us up in a word of prayer, please.
Thank you, Mr. Chairman. Father, in the name of Jesus, as we come before you, we ask for your leading, ask for your guidance, your wisdom, as we do the business for the people of this great state of Georgia. We thank you for all your many blessings, Lord. In Jesus' name, amen.
Amen. All right. First bill we're going to hear this morning is going to be House Bill 1216 by Floor Leader Mcdonald. If you'll come forward, please.
I'm bringing you today House Bill 1216. Make sure we're on the right LC number. That's LC 393269S. Is that good with you, Mr. Chairman?
That's it.
Okay. As you know, and some of you may have personally experienced, when someone makes the choice to flee from a police officer, that decision not only puts the officer in danger, but also endangers everyone on our streets and roadways, and even the criminal that's fleeing the officer. Georgia State Patrol is here today, and they can also tell you running from law enforcement has become somewhat of a game to offenders in Georgia. This bill will reinforce how seriously the state of Georgia takes the reckless, dangerous, and the deadly behavior. Under the current law, Georgia law, fleeing and eluding law enforcement officers is an aggravated misdemeanor unless the offender commits certain other offenses while fleeing and eluding, in which case it's a felony. HB 1216 increases the penalties for the first, second, and third offense of fleeing and eluding. It makes the fourth or subsequent offense a felony. What we're looking at is in changing these penalties. We're in the first offense, we're moving the fine from 500 to 1,000 and 10 days to 30 days. On the second offense, and these are still, they're not felonies unless something I will go through in just a second. So on the second offense, the fine's going to go from 1,000 to 2,500 and going from 30 days to 90 days. And on the third offense, it's going from 2,500 to 4,000, 90 days to 180 days. And on the fourth offense, it is now a felony, and you're going for no less than 5,000 and no more than 10,000, no less than 12 months in jail, or no more than 10. As I mentioned before, current law provides that if any offender commits certain other offenses while they're fleeing and eluding, they're guilty of a felony. What we're changing in HB 1216, that if you're fleeing, eluding an officer, if you cause an accident to another vehicle while you're doing the fleeing or eluding, that will automatically be a felony. Also, driving on a sidewalk, overtaking a stopped school bus while its signals are out, laying a drag, reckless driving, and reckless stunt driving. Additionally, when going through HB 1216, we had a friendly amendment was made during the subcommittee, which it passed out of subcommittee to the full committee. Included in the amendment included all forms of DUI as an offense, which would elevate fleeing and eluding to a felony. Currently, the code only allows for the DUI provision to take effect of offender if he's having just a DUI. The friendly amendment now makes any person under the influence other than with drugs or alcohol to the point that it's unsafe to drive will also be considered a felony. Finally, HB 1216 had a little small change, that the impersonation of a police officer with a vehicle, motorcycle, it did not have any type of device that was being used to pull somebody over. And we added the words blue light in the code. So it cleared a little bit of that up on impersonating an officer. Mr. Chairman, I'll yield for any questions.
All righty. Do we have any questions from the members of the committee? Chairman Petrie.
Thank you, Chairman. And Representative McDonald, thank you for being here today. I want to ask, will you clarify what you just said about DUIs? Because we're looking at eluding a police officer and the statutes surrounding that. Explain maybe a little more, in a little more detail, what you just added about how DUIs are influenced here.
Yes, sir. Chairman Petrie, currently only a DUI, if you're fleeing law enforcement and you're under the influence of alcohol 0.08 or greater, that would be a felony. If you're under marijuana, any other substance, it would not be considered a felony. This law brings everything together. Any influence or impaired driver, over whether it's drugs or alcohol, that will be a felony. Right now, it's just DUI.
Okay, thank you. Any other questions from members of the committee at this time? Anybody online have anything they want to add to us? Okay. All right. What will be the desire and will of this committee?
Move to pass.
Okay, motion do pass. Is there a second? Okay, there's a motion do pass and a second. LC 393269S on House Bill 1216. All those in favor?
Aye.
Aye.
All those opposed? Okay, the ayes clearly have it. Thank you. You're on the
Thank you,
rules.
Mr. Chairman. Thank you, committee.
Our second bill we'll hear today will be Senate Bill 358, Senator Kirkpatrick. Either one, your pleasure.
Thank you, Mr. Chair, members of the committee. Good to see many of you again, as I've already been through your subcommittee with this bill. Senate Bill 358, the LC number is 480525S. Is that what you have, Mr. Chair?
Yes, ma'am.
Okay. This bill is the result of a conversation between Colonel Trish Ross, former director of the Vector Center, the Veterans Education Career Transition Resource Center, which helps military members transitioning out of service into civilian life, and Chris Wigginton, executive director of the Georgia Public Safety Training Center, who's with us today somewhere. And what the bill does is it provides for tuition reimbursement for veterans coming out of service who want to pursue basic law enforcement training. This program is already available to police chiefs, wardens, emergency medical personnel, and communications officers. It does not include travel expenses, meals, or lodging, and it's subject to appropriations. We have many vacancies in our law enforcement agencies across the state. By making it easier for interested veterans to access these training programs, we can both keep more of these highly trained individuals in Georgia, and we can also help our law enforcement shortages. This bill passed the Senate unanimously, and I'd be happy to answer any questions.
Yes, ma'am. Thank you for bringing this piece of legislation to us. Chairman Petrie.
Thank you, Mr. Chairman. And Senator, thank you for bringing this. I just wanted to mention this works real well with another piece of legislation that I'm working on and you will be working on the Senate side related to encouraging military retirees to live and work in Georgia by eliminating a portion of their state income tax. And you were right. We have, unfortunately, very difficult today to recruit law enforcement officers with the climate we're in. And you're honing in on that directly. And so I appreciate that. Appreciate the good work you're doing.
Number 23, who is that down there?
Mr. Chairman.
Yeah, go ahead.
Mr. Chairman, your committee, subcommittee had under consideration Senate Bill 358 and came back with a do pass. And I'd like to make that motion at this time.
We do have one person online that would like to speak. So if you'll hold just one
Okay.
second, please. Representative Jenkins, you online there, want to say something? I think you're muted. Can you unmute?
Apologize, having problems with my system here.
Go ahead.
Again, I'd like to thank you for bringing this bill, and I just want to add one thing that you didn't mention. It's another very important factor here is veteran unemployment. So this in addition to serving a very important need in our public safety community, it also addresses the other issue that our nation faces, which is very high veteran unemployment rate. So again, thank you very much.
Thank you. Chairman Green at this time.
Thank you, Mr. Chairman. Mr. Chairman, I'm move that Senate Bill 358 be taken up by this committee with a motion of due pass.
Do I hear a second?
Second.
Okay, motion made to do pass and second. Senate Bill 358 LC number 480525S. All those in favor?
Aye.
All those opposed?
Aye.
Motion carries. Thank you.
Thank you, Mr. Chair.
House Bill 1145, Representative Gullett will now hear your bill.
Thank you, Mr. Chairman. House Bill 1185, we're working with LC 393260S. Related to the Georgia State Indemnification Fund. And what this does is it adds COVID-19 as a qualifier for the death benefit. We've mirrored federal language with this, and right now there's no directive outlining how and when a deceased qualifies for the benefit related to COVID-19. That's caused DOS to spend a lot of time investigating these benefit applications. And so that's what we've done is added COVID-19. And we've also, just one point to that, is time-based, so it limits exposure. The December 31st, 2021 was the end time, and I'm happy to go through the bill if we need to for where those are. If you look at 45 through 48, that's the definition of COVID related to this. This is only for public safety officers, 51 through 54. Public safety officers means a law enforcement officer, a firefighter, emergency medical technician, emergency management rescue specialist, state highway employee, or prison guard. And then if you look at lines 111 through 114, that's where we put the qualifier. Department shall consider death of a public safety officer, which occurred between March 1st, 2020, December 31st, 2021, to have occurred while in line of duty if the public safety officer was diagnosed with COVID-19 within 45 days of such a public safety officer's last day of duty. That's all the bill does. Happy to answer any questions.
I do have a question for you. So if you're COVID resolved and then you pass away from another illness, does that go back and consider you COVID? Do you know the answer to that question?
So I think if it's within the 45 days, yes. If you died within the 45 days of having that COVID positive test, even if it is resolved.
Okay.
There is minimum numbers of these, and talking to, it's not like there's hundreds of these out there. This is, I think from the firefighter standpoint, were there 11? So 14 on the firefighters side. I think from the 911, it was less than 10.
Okay.
So it's pretty small numbers considering.
Okay, we got a question from Representative Holcomb.
Thank you, Mr. Chairman. And that you anticipated my question, which was if you could give us context of the numbers. You gave us some, but do you have an aggregate number?
I do not.
Okay, thanks.
I think they're still coming in, some of them, because they got applied for. DOS had to reject some, but I don't have an aggregate. But it's pretty small. If all the firefighters in Georgia were at 14 and no one else is qualified to die and get the benefit.
Chairman Clark online, if you have some comments.
Yes, I have one question. This bill is currently written, and I'm sorry I didn't ask this in subcommittee. I just thought about it now. As the bill's currently written, it would not include guardsmen.
Guardsmen. So I think yeah, so just the state identification plan today does not include guardsmen. So no, they don't.
No, I'm pretty sure a couple of years ago we added guardsmen to the state.
We have prison guard, if you consider a prison guard a guardsman, but
No, National
Guard, I guess is what you're talking about.
Yes, and they are included in the state indemnification.
We didn't touch that. There were some, so if it was in there, it should still be in there. We didn't redefine what public safety was. as part of this bill. There's a number of changes, but that was just legislative council doing what they do to make the bill better, but we didn't change the definition of what a public safety was.
So because I'm pretty sure we added guardsmen to that definition of public safety a couple years ago.
Yeah, it's not in there as of today. So, meaning we didn't change it as part of this bill. So I can't speak to that.
Good, thank you. Number 12 down there, who was that? Is that Colonel Hitchens?
To my seatmate there, who had the question, I served on the State Identification Commission for 12 years, and guardsmen were not a part of it. I carried a public safety bill a couple of years ago that provided for mental health for all public safety employees across the state. And I included guardsmen in there, and it was taken out because they have their own system, primarily through the federal government as part of the our national defense. They come under the Department of Defense. About 90% of their funding is actually coming from the federal government. The state only contributes about 10%.
Thank you, Colonel. Chairman Petrie.
Yeah, thank you, Representative. I have a question, and I apologize for not studying this measure as well as I should have in advance. I do have a concern, so I want to make sure I'm clear on this. So if someone has had COVID, even if it's not causative to their death, you're including them. Is that correct, or is that not correct? That's the way it reads.
Yeah, if they've had a positive within 45 days, it just mirrors the federal language. We didn't change. This is the direction of that the feds have provided, and that's what we've included here. We didn't change that direction, but within 45 days, if they're a positive,
if they had any positive test within 45 days of their death,
right,
even if it was insignificant as it related to their death.
That's right.
Something to think about there. All right.
I have
Representative Gravely online has a question, so give us just one second. If you will. Representative Gravely, you with us?
Yes, sir, Mr. Chairman. I think with Firefighter Thayer, I just saw that he was approaching the mic. I would probably defer because he's probably going to talk about the same things I was going to talk about. If Mr. Chairman, if I may come back after his comments.
Certainly, to my friend. Thank you.
Good morning. My name is Dennis Thayer. I'm the chairman of the Georgia Fallen Firefighters Foundation and the national representative to the National Fallen Firefighters Foundation. And our mission is to assist public safety families once there's been a line of duty death. And part of that is the benefit process. So the goal with the bill is not to include anybody that may have had COVID within 45 days. COVID had to have been a contributing factor to the death. It has to be on the death certificate that COVID is a contributing factor. What happens in these cases sometimes is they get sick, they get COVID, they're put in the hospital for 6 months or 4 months or whatever it is. And at the time of their death, they may not have COVID any longer. You know, they may test negative for COVID, but what they died from is the long lasting effects that the COVID caused. Pneumonia is a huge one. A lot of people end up, the death is caused by pneumonia, a fungal type pneumonia that is caused by the COVID. So either the death certificate has to say contributive factors to COVID or COVID, but very seldom is COVID contributed as the sole factor for somebody's death.
Thank you. Any questions at this time? I'm going to come back to Chairman Representative Gravely. Are you still with us? You have something you want to add?
Yes, sir, Mr. Chairman. I just wanted to reiterate what Firefighter Thayer said, that the proper guardrails are there, that this isn't someone who received a positive COVID test and with 3 days they were fine and back on duty, and then, you know, had some accident or whatnot. This is something that where COVID would have been a contributing factor, where they've gone into the hospital, where it triggered a pneumonia, it triggered a bacteria or a fungal disease or a fungal reaction, that this indemnification would take place. As we know, when there are parameters put around, whether it be our educators, our medical workers, where temperatures are being taken in an uncontrolled environment, But when public safety personnel show up on a scene, whether it be an emergency, whether it be a domestic or a call out for any sort, that there's no time to take a temperature. There's no time to ask whether or not the residents, the perpetrators, or the victims on that scene are wearing a mask if they've been COVID tested, whether it's come back negative or positive. These are individuals, men and women, who are responding to a call that's been dispatched, walking into an uncontrolled environment. And if there's 2 or 3 members of a family, or a situation where an individual that they've been called out to assist or apprehend is in the midst of a positive COVID test, highly contagious, that these individuals are exposing themselves to, and then contract COVID due to that job or that job description or that duty requirement. That's what this bill is trying to target. And then suffer death due to that dispatch or due to that call. Thank you, Mr. Chairman.
Chairman Pete.
Thank you, Mr. Chairman. And so that I can be clear to my good friends, we all want the same. What I just discovered from you is we agree wholeheartedly. Everything that was just described by Micah, everything that you described, sir, we want the same thing. I think what we're seeing here, I think what I'm seeing here, I'll just say that, is that the language doesn't say that. It just says, now it does leave it to the department to consider that. So the question is to everyone here is, should we not say what you just described? What you want is what I want this to say, but that's not what this says. And so we could amend it to where it makes it clear that it is indeed a factor related to their service and causative. And we have legislative counsel working on that. It appears that's been done, so we can, I'll present that in a moment. Let me go grab it, Mr. Chairman.
Thank you.
But I want to make it clear I want to accomplish exactly what you want. Very supportive, but I think the language is important.
Is there anyone else that has any questions at this time? Representative Holcomb, you have.
Thank you, Mr. Chairman. I think the bill provides a fair amount of flexibility in terms of these are factors to be considered, but then they would drill down and get the actual data and the more elaborate explanation like what we heard, correct? So in other words, these are
Parameters.
Exactly, yeah. And thinking of it in sort of a similar sense is those that acquire diabetes and served in Vietnam, by law, there is a recognition that that is service connected, that your service in Vietnam increase your risks and factors. And so by law, it's presumptive that you have it. And it seems to me that's what we're kind of doing here. But at the same token, they're going to do an evaluation and see, was there actually a nexus between COVID and their passing, correct?
Yeah, I don't know. My understanding, I would defer to Dennis. I don't know exactly how the fund works. I know what I was trying to do here. I don't know exactly the process for it though.
Thank you. Yeah, yes, sir. You're absolutely correct. One of the things that prompted this bill is DOAS was trying to process the applications, was having a lot of, it's hard because there's no guidance for them. And so they were kind of having to guess along the way. There was an appeals hearing for 2 that they turned down. The governor tabled those because the governor did not feel like there was enough adequate guidance for them to make those kind of decisions. So the governor asked us to come up with some way of trying to address that. So the governor obviously saw the need that, some of these are definitely work related. So that is our goal. As we looked at what the federal guidelines do in the Public Safety Officers Benefit Program, and we basically took that terminology, and the guidelines are basically, and yes, the application process, which I usually complete for the families, is significant. It has medical documentation, death certificate. If the death certificate does not indicate COVID was at least the initial cause, which I can tell you in all of them, every single one that I've dealt with, and I am doing some law enforcement ones also, COVID is on the death certificate. So if that's not on the death certificate, they're not going to get the benefit. It's got to be part of it. Again, it is a little bit presumptive because it is literally impossible to determine whether somebody gets it from somebody else or not. You have people that walk up and spend 2 minutes with somebody that's COVID positive and they get it, and you can have 6 other people walk up and spend time with those same people and not get it. So there is a presumptive edge to this, that yes, if you got it at work and you've been working and you come up within 45 days of working and you get this and you die from that, it is presumptive that's where it came from.
Right. And the evaluators would also hear, for example, if somebody were in the hospital for a long period of time, they would get that context.
Oh, absolutely. I can tell you, I work closely with DOA staff in this, and they get the medical records. Some of them, we don't give them all the medical records up front because it's thousands of pages.
Right.
Most of these folks were in the hospital for 2 weeks to 7 weeks before they died. But yes, that's what we're looking at is, number one, did they work in the last 45 days? Did they physically work? And I can tell you the fire side, all of them worked within the last week before they got sick. So none of them are far out with 45 days. That's just a guideline that we use with the federal benefit. They all had all of them were in the hospital when they died. And there was significant treatment to that and significant illness to that. And a lot of them had been their prolonged illness.
Okay. Thank you. And if I may, Mr. Chairman, just make sure
Please,
that I
go ahead.
understand it and everybody else. This is not saying that if you had COVID, you get the benefit. It's rather they're going to consider it in terms of the contributing factor that it had in your death. They are going to do an analysis.
Yes,
correct?
they're going to do an analysis, but there's a presumptive. That's the problem they're having now, is they're doing an analysis, but there's no guidance to that. What is, what isn't. So this does have a presumptive element to it that
With the timeframes. and
if you meet
everything.
all these parameters, that yes, we're going to say it's presumptive you got it from work.
Okay, I got it. Thank you.
Online, we have Representative Frazier who has a comment or a question.
Yes, I have a question. Thank you, Mr. Chairman. I have actually a couple of questions. First of all, I want to know, under the list of qualifiers, is the DNR officers, are they included in that? And my second question is, most of it has been answered. I agree with Representative Petrie in the process to make sure that we have the guidelines. And I'm hearing the word evaluator or from the colonel there. So is there a board that will evaluate this with medical professionals on this board to determine the cause of death? Because with COVID, there's multiple causes. I understand that it has to be related in that 45 days, but is there a board, or do I call it a board, or just evaluators? And these evaluators, are they professional doctors that determine whether that person and that family get those benefits?
We're going to get you an answer to that question. Go ahead.
Yes, ma'am. To your first question, DNR officers, I believe all state law enforcement officers are included on the indemnification, under the indemnification law. We did not change terminology with who was included. Whoever was already in indemnification law was included in this. As far as the evaluation process, DOAS has attorneys that in that program that with the workman's comp program, they evaluate the application to make sure it meets the guidelines. They approve it, and then there's some sort of a upper approval process, which I've never been involved with, so I don't want to speak on. If a benefit is denied, then it goes in front of the indemnification committee, which is chaired by the governor, and an appeal process is there. Basically, the major documentation they're relying on here is a death certificate, a death certificate, and the supporting documentation from the employing agency. Did they make do they meet the qualifications? What were the dates that they worked? Did they go on calls? What did they do? And as long as they meet those qualifications, then we look at the death certificate. Now we submit supporting medical documentation that, to support what the death certificate shows, and we'll provide whatever they ask for. But I think it's about an inch thick book that I submit when we submit one of these applications. I think there's adequate documentation for for just about anybody to figure out, yeah, this is what caused it.
Mr. Chairman, I have one follow-up, if I
Go
may.
ahead.
Thank you so much for that clarification. And so my final question is, this is retroactive, correct? To go back to 2020, I believe that's the date. And also to date, do you know how many cases we might have pending that from officers that have passed away that will be benefiting, and families that will be benefiting from this if this legislation is passed?
I don't know exact numbers. I know in the fire service, there are 14. I do not know in EMS. I don't know of any in EMS, to be honest, but I'm not saying they're not there. And I do not know about law enforcement. I can tell you as of October, DOAS had approved 9 of the applications, and they had 11 that they were looking at that they didn't feel that they could approve. I do not know what the number is, overall number is.
Thank you.
Chairman Petrie.
Yes, sir. Thank you, Mr. Chairman, again. Okay, so, sir, very helpful comments. I just want to comment to you. I want to make sure you're real clear. What I'm trying to do, we want everybody to get this entitled to it. I think that I learned a lot from you just then, and I think we're saying the same thing. We're trying to get to the same point. I think if we get you the right language, it's going to be less likely people will not support this measure. So we want to make sure the language is clear. You're going to get others asking the same questions we are. So I want to get your opinion, and Representative Gullett and Representative Grabbley as well, who's very knowledgeable of these affairs, of this, what I believe would be an improvement and would be helpful for you, as you just described, I think, in making determinations. And so if we added the language because what we've got here is the department shall consider the death of a public safety officer, which occurred between March 1st, 2020 and December 31, 2021, to have occurred while on the line of duty if the public safety officer was diagnosed with COVID-19 within 45 days of such public safety officer's last day of duty. And that's where it ends now. And we would say, and such diagnosis was the cause of or contributing factor to such public safety officer's death. That's what you're trying to do. I'm asking a question. Isn't that what you're trying to do anyway? But then rather than being so nebulous, right now it's just completely nebulous. Would that be beneficial to you? Would that be helpful in this matter?
Yeah, yes, sir. I believe that, meets what we're trying to do. And if that's what we need to do to clear it up, absolutely. Yeah, I think it's important to two things: one, the COVID, and two, the contributing factor, that it's a contributing factor.
Yeah, just contributing factor, but that gives you, now you have something to stand on. It would, as you really got something to stand on right now. You really don't. It just says it's wide open.
Chairman Grabbley online, you have something?
Thank you, Mr. Chairman. Listen, I truly appreciate the robust discussion and debate on this matter. And I would actually commend my colleague, Chairman Petrie, because I think that will clarify exactly what we're trying to do here. There is a high bar. And I want to make sure that everyone knows this is not just a rubber stamp, that if an individual had COVID, that we just presume then that the death is related, and then we're just going to rubber stamp it. That there's a high bar when DOAS goes through these applications, considers the medical documentation, and the application is therefore reviewed. And as Firefighter Thayer indicated, that I believe it was 9 or 7 or 9 of the ones have been approved, but 11 have been denied. So I would actually offer my appreciation and thanks to Chairman Petrie, because I think that language will actually help clarify exactly what this is doing. And I appreciate the input there. Thank you very much.
Representative Clark, or Chairman Clark online, you have a comment?
Yes, I looked up some old bills, and under the definition of law enforcement officer in the state indemnification fund, both the Georgia National Guard and the State Defense Force are covered with this bill as well, because of the definition of law enforcement officer in the bill under public safety officer.
All right, thank you.
Chairman. I just wanted to mention one other thing. I just want to call attention to another reason that I think if we get the language right, it's important. I know that in this measure, we're speaking to March 1, 2020 to December 31, 2021. But remember, we'll set precedent here. And we may be dealing with COVID for 10 more years. So to me, it's not, I mean, today we're talking about just now, but we're building a foundation for what we do going forward. We still have COVID, and I suspect it's going to be around a long time, you know, or it could be. I hope not. But I think all of that, if we can get the language just right, rather than just plus or minus, I think it'll be helpful going forward as well. Maybe many others, rather than talk about the numbers we're talking about today, maybe many others to come, sadly or unfortunately. Is that not correct? Is that not true?
No, sir, I agree with you. And I have no heartache with the language change. And I want to thank you for taking a proactive approach and trying to help us get this right, because that's what we're trying to do.
Okay, what would be the desire of the body at this time?
There's no further discussion, Chair.
Okay, no further discussion at this time. Chairman Petrie.
I'd like to offer an amendment to this measure on line 114.
We need a motion to do.
Oh, I'm sorry.
Chairman Green.
Mr. Chairman, I'd like to make a motion of due pass. Which one is it?
House Bill 1145.
1145.
Is there a second? Okay. Motion and a second. I will now recognize Chairman Petrie for an amendment.
All right. On line 114, after the word duty, we would add the following. And such diagnosis was the cause of or contributing factor to such public safety officer's death, period.
Okay, he's making that in the form of an amendment.
That is my amendment.
Okay, do I hear a
Mr. Chairman.
second?
I'll second that amendment.
Okay. All those in favor of the amendment?
Aye.
Aye.
All those opposed? Okay, amendment does pass. Now, all those in favor of House Bill 1145, LC 39326OS as amended, would you please say aye?
Aye.
All those opposed? Motion carries.
Thank you, guys.
Thank you. Thank you for being here with us today.
Thank you very much.
Got one more simple bill on our agenda here today. It's going to be House Bill 439, Representative or Chairman Hitchens, if you would, please. It's okay.
And because I didn't want to keep all these people here. I know this may take a while. I think it took an hour and a half in subcommittee. But, I want to make sure everybody's got the right bill. And LC 393298S.
Yes,
Substitute to House Bill 439.
yes.
We just got it out this morning. I just got it about 8 o'clock myself. So, and I'd just like to say before we get started, this has been a lot of work involved in this, not just for me and people that have helped me with, but the prosecuting attorneys council, the defense attorneys, the Department of Driver Services, it runs the gamut. Everybody's been involved, and I'll just show you. We've got 5 pages of changes that have been made since we started this. So we've tried to incorporate everybody's wishes into it the best we can and keep the bill to do what it was intended to do. And what it really involves is first time DUI conviction that you get the interlock ignition device placed in your car. And I know a lot of people have said that they ought to get a mulligan on the first time. I've looked at the statistics. So, I've been dealing with this about over 50 years, and DUI has gone from where it used to be a slap on the back and kind of wink of the eye to being a pretty serious offense in today's society. And in fact, about 30 to 40% of all the fatalities in Georgia are caused by DUI drivers. And last year we had the highest number of fatalities in our state since 1974. Actually, it was 1,730 people were killed in traffic accidents in Georgia, 695 in murders. So 3 times as many people get killed in traffic accidents, and about the same number get killed by DUI drivers as get killed by murderers. I can tell you, if we had as many people murdered as we have killed in traffic accidents, we'd have a police officer on every corner in this state.
Absolutely.
But, and people say they're accidents, and that's why they don't pay as much attention as they do. But, some are, some aren't. When you intensely become intoxicated or take drugs and get on the highway, you're not only taking your life in danger, but you're endangering a lot of other people. And what happens is, if you lose your driver's license, you're not supposed to be able to drive. Well, people don't pay any attention to that. They drive on a suspended license. You catch them when their license is suspended, then you take your tag away from them, and that still doesn't stop them. This interlock device, you blow in, I think most of the people on the committee are pretty familiar with it, but if you blow into the device and you have alcohol in your system, your vehicle won't start. The new device, if somebody else blows into it for you and gets it started, and you ride down the road, several minutes later, it'll require you to take another test. And if you have alcohol in your system, then it slows down and gives you the opportunity to pull over the side of the road and stop. But it ceases your ability to drive pretty significantly. And I think statistics show that there's been about let me see here. I got so much information. You can see the bill's about 30 pages long, but the FBI and the Center for Disease Control say that most people drive 80 times under the influence before they're ever caught. Michigan State did a study about 15 years ago, and I don't know what their methodology was, but about 70 times in. 30 or 40 years ago, you could drive 250 times, according to the research statistics, before you got caught. So it's tightened up, but it's still a significant problem. And this bill is intended to try and rectify some of the problems. The elephant in the room is how much it costs. Everybody's concerned about that. And I've handed out a handout to you that identifies all the costs involved. And it's actually about $600, $3.33 a day, I believe it is. So it's not insignificant. There's language in the bill that provides for people who don't have resources to get a reduced or free device. And there's also some of them think that maybe the company that's involved in here will not take the device out and still continue to charge. There's a verbiage in there that requires, once your time is up, that it be removed, and you no longer can be charged for it. So there's a lot more involved, and I hate to push it, but Chairman Petrie and I both have a meeting with the speaker and some other people at noon, and I would like to move on. And sitting here with me today, I have Gilbert Crosby. Miss Pam Bettis has been working with me. She's a Solicitor General in Henry County, and she's dealt with this for many, many years, and very much more expert on it than I am. But Mr. Gilbert Crosby here with the Prosecuting Attorneys Council would like to speak on the bill.
Thank you, Mr. Chairman.
Thank you.
If I may.
Just very quickly, once again, by way of introduction, my name is Gilbert Crosby. I'm one of two senior traffic safety resource prosecutors with the Prosecuting Attorneys Council of Georgia. But I'm here today primarily speaking before you, having been deputized by the Georgia Association of Solicitors General, Todd Hayes out of Cherokee County and Pam Bettis out of Henry County. Send their regrets today, previous commitments. Just want to convey, generally speaking, to the committee, we have been a part of Georgia's Solicitor Generals who handle misdemeanor prosecutions and deal with the bulk of DUI cases, have been involved in the construction of this bill. It is like many grand compromises, not perfect, but it does have a lot of instruments in it that will have the potential to positively affect traffic safety and have at least some impact on this one aspect of DUI as relates to when the driver has had more alcohol than they should be. And because of that, we do believe it has potential to have a beneficial effect. That's the main idea I just wanted to convey. Also, I am here available to assist if there are technical questions about anything the bill may or may not do.
Okay. All right. At this time, we want to hear from any members of the committee. Any members have questions for the author of the bill at this time before we hear some testimony? Representative Frazier, you have a comment or a question?
Yes, sir. Thank you, Mr. Chairman. I do. Colonel Hitchin, thank you so much for this legislation. My question to you is, how many companies do we have to install these devices on vehicles? Just making sure we don't have one company with a monopoly on this that will determine the price scale.
And I've heard that, but I can't, I do have somebody here who can tell me right quickly.
There's
Yes, sir.
10 manufacturers that are certified by the Department of Driver Services to provide these units. There's probably close to 100 statewide installation centers.
So Representative Frazier, he said that there's close to 10 vendors that provide, manufacturers that provide the equipment and 100 installers around the state.
There are 10 that are
Yes, sir.
certified by Department of Driver Services.
All those are certified by the Department of Driver Services.
Yes, sir. And Mr. Chairman, we do have it where the cost is monitored and it's affordable and not, these companies cannot just raise fees.
We'll let the author of the bill speak to that.
Well, it's a set rate, but there are provisions for people that don't have resources. And it's up to the judge to make that determination. He makes that pretty much in the same fashion that he makes it in other cases that don't relate to DUI or traffic safety.
Thank you.
We're going to hear some testimony at this time. And I've asked that we keep our comments brief because this did come through subcommittee, and subcommittee is the place where we really need to testify and give testimony. So those who are on the sign up sheet, let's see. I don't want to start off with Ms. Travis just yet, but let's see. Erica Egley.
I think it might be helpful. We have some additional testimony that wasn't at the subcommittee from the Students Against Drunk Drivers.
Okay, let's go with Barry Shrink at this time. If you'll come forward, we'll circle back around to you in just a moment.
Thank you, Mr. Chairman. Members of the committee, my name is Barry Schrank. I'm president of Taggart's Driving School, but I'm here this morning to represent GARD, Georgia Association of Risk Reduction and Defensive Driving Educators. And basically, when I testified at the subcommittee meeting, a lot of changes were made, administrative changes, language was made, but there's still one problem with the bill. And I met with the bill sponsor this morning. Not to speak for him, but I think he's in agreement that we need to make a couple of changes. First, let me explain the way the system works quickly. If someone is required to get an ignition interlock device, the first thing they would do is go online to the Department of Driver Services, and there's a list of about 10 manufacturers there. They would contact the manufacturer and make all the arrangements for payment directly with the manufacturer. And the next thing that happens is the manufacturer would have a contractual relationship with the installers, those 100 throughout the state. And I think they all operate basically the same way. So the manufacturer collects the fees. They provide the instrument that is approved by the Department of Driver Services, and they send it to the installer. And then the installer is paid by the manufacturer to install the unit in a car. Once a month, every 34 days, at least within 34 days, the person who has the ignition interlock in their vehicle has to come back to where it was installed. And there's a computer system with software that's put on there to make sure that there's been no tampering with the device. Under the existing law and the rules and regulations of the Department of Driver Services, if there has been any tampering, then the Department of Driver Services is notified, and then they will withdraw the limited license, the interlock license that they have to use that device. So the rules and regulations have been in effect for probably 25 years. The department is regulated. All the install locations are licensed by the Georgia Department of Driver Services after going through the normal application process, which includes submission of fingerprints to the GBI and the FBI to make sure that the folks who are going into any of these businesses that have a driver's license at the center of it are the type of folks you would want to have in business. Specifically, on page 28, and I just received just shortly after the chairman did, Chairman Hitchens, the bill LC 393298S this morning about 9:30. And my concern is some of the language that's on page 28. And that is, we're calling a provider center a manufacturer or a install center. And either of those two entities have certain responsibilities. And what I'm concerned about is the way the language is, that someone will be charged for something that they have no responsibility for. So for example, the manufacturer collects the funds. I don't know whether they do it electronically or by check or by credit card, but they get the payment. And then once the install person on the ground has done the work, they receive payment from the manufacturer. So there's certain things that the install people are responsible for and certain things that the manufacturer is responsible for. So I think some of the language has to be changed. For example, on line 711, that's line 711. It says a provider center shall be authorized to charge the person whose vehicle is to be equipped with an ignition interlock device, et cetera, et cetera. What is a provider center? Is that the installation center, which is what I would call it, or is it the manufacturer, which is what I would call it? So for example, a provider center should say the manufacturer shall be authorized, unless you want to be able to, in the future, to allow the installation center, if they change the business relationship with the manufacturer, between the manufacturer and the installer. But the way the system works today, used to be a franchise system. You bought a franchise from a manufacturer years ago. But today, there's no money exchange with the install people except for the check or electronic transfer of funds from the manufacturer. So on this page, there's that language I think should be changed to reflect actually how the system works and how the Department of Driver Services regulates it. So other than that, it would probably take me too long to tell you which page and which line needs to be changed, but
Okay.
I think your legislative council probably has a drift of what I'm saying and can fix it.
Okay.
But you have some verbiage to change it if anybody here would like to make that amendment, don't you?
Yes, sir.
Okay. And I would agree to that. I think that's very appropriate. He works in the system and understands it, and
We'll come back to you here in just a little while if that need be. Thank you, Barry.
You're welcome.
Okay. Let's see. Shireen Shavanka. I apologize for butchering the pronunciation of your name.
Chairman Collins and distinguished members of the committee. My name is Shreen Javkhani, and I'm a junior at Chattahoochee High School in Johns Creek, Georgia, and I serve as a member of the SAD National Student Leadership Council. I'm here to convey our support for HB 439 and urge the swift passage of the life-saving measure, and I'm joined with our president and CEO, Rick Burt. Today, I represent 18,569 members of SAD from across the Peach State. My fellow students and members wish me to convey their desire to see this measure advance as a sensible and necessary countermeasure to curb impaired driving. This measure makes critical enhancements to the existing law, and from our perspective, it most notably removes a provision that limits the use of ignition interlocks to those over the age of 21. HB 439 would make interlocks available for use by all drivers. At SAD, we empower teens to make positive choices one decision at a time. We understand the value of a personal choice, and when one chooses to put others in harm's way, there's a need to rise to protect the public good. I'm tired of parents losing their teens to something that's completely preventable, and I'm sickened by the number of lives lost due to impairment. I know you join me in grieving with each mother, father, brother, sister, teacher, and community member who wakes up with that pain of losing a loved one due to impaired driving. HB 439 has the power to prevent that pain and modernize this state's law. Our members, the students of Georgia, call on you today to vote yes in advancing this measure. I thank you for your time and your consideration.
Thank you. Let's see, Frank Harris is online virtually. Frank, are you with us?
Yes, Mr. Chairman.
Please,
My name is Frank.
Please keep your comments as concise and brief as you possibly can. We have several other things we have to do here today, but thank you for being with us. Go ahead.
Yes, Mr. Chairman, I will be brief because I did testify in subcommittee. I just wanted to, my name is Frank Harris, Director of State Government Affairs for Mothers Against Drunk Driving. Our top priority in states continues to be legislation like this. I did share a letter with the committee as well as my written testimony, but this legislation is about one thing, saving lives. And that's what this legislation will do. Real briefly, my last point, MAV strongly supports this. The Insurance Institute for Highway Safety has studied these laws, as with many other organizations. This could reduce drunk driving deaths by 16% in Georgia. I mean, this is a big deal, considering that drunk driving has ballooned over the pandemic. So again, Mr. Chairman, members of the committee, we thank Chairman Hitchens for authoring this. We urge this committee to advance this life-saving legislation. Thank you.
Thank you for being with us. Brandy, I can't read your last name there.
Brandy Axtell.
Okay.
I'll be very brief.
Yes, ma'am. Thank you.
I am Brandy Axtell. I'm with the responsibility.org, and we are funded by 11 distilled spirits companies. We're a national not-for-profit organization. Our sole purpose is to fight impaired driving and underage drinking, and we've been doing that for more than 30 years now. I want to urge swift passage of House Bill 439, and I want to just make one point that hasn't been made by my colleagues here, and that is with first-time DUI offenders, that's your moment. That's the chance to change that person's behavior and to prevent them from becoming a repeat offender. Most DUI offenders have either a substance abuse problem or a substance use disorder, and about half of them have a mental health disorder that's undiagnosed and untreated. This device makes it impossible for them to drive drunk. The sooner we can get it on the car, the better, and that's why immediate reinstatement of driving privileges with the interlock would be so helpful. So we urge you to pass the bill. Thank you.
Thank you. Okay. Who's next? Erica. Erica.
I'll waive unless there's any specific questions, but I think a lot of the details were covered very well.
All right. Thank you. Jill Travis.
Is it still morning? Oh, good afternoon, members of the committee. Thank you for letting me speak today. My name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. I'm not going to plow ground that I've spoken about previously. I do want to thank the author of the bill and Mr. Lindsay and the Prosecuting Attorney's Council for the work that went into creating the substitute. And of course, Ms. Dolday that made magic out of the mincemeat that we provided to her. I did want to comment on a few matters relative to the bill. Although we worked collaboratively to try to make improvements to the bill, the Georgia Association of Criminal Defense Lawyers does not support this as a measure that will help curb the issue that's trying to be addressed here. I wanted to say that costs do play a huge role in this. And while there is out-of-pocket costs that have been stated to be around $600, we all know, I mean, for all of us that have just appointments to go to, once a month to drive possibly up to 99 miles away to get your car calibrated. It's, again, a life decision that was made wrong, but there's a lot of consequences to it. And one of the things that we'd asked for was to reduce the fines for the first punishment. And that didn't get changed, didn't get made. Specifically, one of the issues that I think may have been lost in translation is on page 17, when we're talking about violations to how to revoke somebody's ignition interlock permit. One of the examples that came up during the course of our dialogue was that somebody was not wearing their safety belt. They were a passenger in a car. They were cited for that, and they that revoked their permit, even though they were just a passenger in another car. The Prosecuting Attorney's Council was great to work with us. They wanted to eliminate that possibility because that's a Chapter 8 violation. And so the language here at line 420 is Chapter 6 of this title. We would ask that words be added to include involving the movement of vehicles. And the reason for that ask is because not all of the violations in Chapter 6 of Title 40 are movement of vehicles. For example, not having insurance, not having proof of insurance on your car is not a moving violation. And yet that would get caught in this trap. The point that the previous speaker made about provider centers, just want to point to the committee that provider center is a defined term in 42.8110B. So that's not an issue. I'm sorry, I'm bouncing a little bit around here, but with respect to the money issue, one of the speakers had said how the judge will make the decision about determining whether or not somebody can afford to have that. And that is written in here. We'd ask for some more clarification to make sure that the fees were as de minimis as possible, and asked for the exclusion of household income. That exclusion was not made. When somebody applies for a public defender, assets are considered, but household income is not. The way I started with the subcommittee, for those of you that were present, was that it's not clear to me 100% that DUI drug, this is supposed to be DUI alcohol, because obviously somebody that's driving using OxyContin doesn't need an alcohol sensor on their car. That's not going to fix it. I'm just saying for the record, I'm not sure 100% that that's clear. I have had conversations with the department, and the Prosecuting Attorney's Council might try and work with the author to make sure that that's covered by the time this bill gets to the Senate, if it goes in that direction. So I do appreciate all of the work that went into the compromises that are here in the bill, and happy to answer any questions that you have.
Chairman Petrie, you have a question?
Yes, Chairman. Thank you. Thank you, ma'am. Did I hear you correct? I just want to make sure I'm understanding you. Do you believe this measure would reduce drunk driving fatalities in this state?
I don't have an opinion as to whether an alka sensor, I mean, I have heard the statistics from other states that have imposed this, that there's a 16% reduction in DUIs or something along those lines. I'm not going to sit here and say this will have no effect, but I'm not sure that this is the issue that solves us getting across the finish line for.
Yeah, I was just commenting on, you made a comment that you didn't think it would accomplish what it was intended to do. So I was curious about why, if you had a reason that I'm interested in understanding if there's a rational reason why this would not be beneficial to public safety. I'd like to hear that if it exists.
I don't know that the interlock device in and of itself is going to be placed on a lot of vehicles. I think that that a lot of people will opt not to have it. And to the extent that we're assuming everybody's going to be doing this, and then that's going to make our roads safer. I think that that's just something that is nice to say, but I'm not sure that it's true in reality.
So the alternative is they would just have a suspended license, or what would the alternative be for them? What do you think they will do? I'm learning from you. What would they do instead?
Under the current law, they would have under the current law, they could right now. We have lawyers in our organization that recommend somebody go get a ignition interlock device, like they're, and that's an option. It's the requirement of placing it on here. There's limited driving permits that are possibilities. There's just taking a hard suspension as a possibility. But you're also imposing a punishment before there's actually a conviction. In some instances, if the judge makes this a condition of bond.
Thank you.
Thank you. Any other questions at this time? Chairman
Well,
Hitchens.
in response to that, I would just say that 34 states already have this for first offenders for DUI. And in West Virginia, there was a 60% reduction in DUI fatalities. Louisiana, 41%, Delaware, 40%, Vermont, 40%, Arizona, 34%, Kansas, 32%, Oklahoma, 29%, Arkansas, 25%, and Mississippi, 19%. And what really shocked me, and they haven't come forward today, but 2 people on this committee have had parents killed in DUI fatality-related accidents that I was completely unaware of until we had a subcommittee meeting.
Any other questions for the author of the bill at this time? I don't believe we have any other testimony at this time. Number 25, who's that down there? Is that Chairman Powell?
Thank you, Mr. Chairman, and ladies and gentlemen of the committee. I've got a few comments from a historical perspective that I want to talk about. I want to thank the author of the bill, Chairman Hitchens, a friend of mine, a professional law enforcement man all of his career. He followed me behind chairing this very same committee this is in. I want to thank the people that testified today. And I want to talk about a little historical perspective, maybe about the only thing I can lend to this issue. And I want to spell out my concerns to this. When I was elected and was sworn in 1990, Governor Miller was the governor at that time. And we made a rapid change to try to change the behavior of people driving. And we passed numerous DUI bills that year or through the next 8 years, because nobody upholds a drunk driver. This was a societal problem more than it is now, but it's still a problem today. And we worked with this issue, and we made a lot of progress over the years, whether it was and I don't know that anybody really, unless you've been involved in this for years, all these bills used to go to the Motor Vehicle Committee, and there was a historical knowledge at that time from the members about following the chain of what was going on. And, we dealt with a lot of these issues, and we made second and subsequent. We made the first DUI penalties. We increased the penalties on second and subsequent habitual violator charges and all of these things. And one of the things is, as the chairman had said, once upon a time, it was a slap on the back. Then it became an issue. Unfortunately, it also became a money issue in a lot of cases. First DUI, I don't know. I spoke with the chairman yesterday. Back a few years ago, we realized that a first DUI carries a monetary penalty to a person, and that's if the person, in fact, tries to regain their driving privileges. But if they do, first DUI is probably a $10,000. Back in the day when we were active on motor vehicles with this, a first DUI had a financial impact of over $10,000 by the time you look at the fine, the assessment, the DUI school, and all of those things, including the increase in your insurance rates. They were just exponential. I think the chairman told me yesterday is that number is up on the first DUI of probably $15,000 now.
If they get a jury trial.
Yeah. So, you know, and there we get into another situation. And I want to talk about this to the sake of common sense. Over the years, we dealt with this interlock device and we talked about it and it was hotly debated. Does it really do any good? Well, obviously it must do some good in some people's minds because the human mind immediate links, well, if we put an interlock device on a vehicle, somebody ain't gonna be able to drive. Not true, folks. There's an exorbitant number of people that if they get a citation or they lose their license, they never go back to get their license. Quite frankly, because they can't afford it. And I'm not saying that money makes a difference, but I'm talking about the real world, how things work. You have people that drive without a license. The chairman said it himself. They do because they can't afford it. We have people, what good the interlock device for somebody who does it? Well, they just drive another person's vehicle without this. One of the things I heard a minute ago gave me a kind of a chuckle to myself. We passed the Hands-Free Driving Act where we're telling these folks, suck on a straw while you're driving down the road. It's a flawed concept. Yeah, does it work? It does in some cases. But in past, and I know this isn't in the past, but what the legislators tried to look at was what's fair. We know that the law of the land and what we've done in Georgia is we've tried to do everything humanly possible to stop DUIs. But we know that you can't do that because drinking or alcohol or drinking a cocktail or a glass of wine, I mean, I'm amazed, but it's a fact of life that people socially drink. They'll have a glass of wine, 2 glasses of wine. I don't know now what the real numbers are, but it's 0.08 presumptive. Means the law enforcement officer can stop you and charge you a DUI even below that, whether you're actually under the influence or not. But this is devastating. And I make no excuses for somebody that drives and drinks. But it's a societal issue that people will go to reception. I don't know a member here, unless they don't drink at all, that might go and have a cocktail or something like that. But they need to learn their behavior. They need to learn the limitations and such like that. My concern with this bill, and I'm going to get into this for your thoughts, and if it means something to you, I hope it does. And if it doesn't, that's the way it is. Over my 32 years of dealing with these laws, we've changed all of these laws. But one of the things that we saw in the committee, and I've seen it, and I suspect a lot of y'all have too, is it becomes a point of human nature of compassion. And it's not a matter of compassion for a first-time DUI offender. But I have seen, and I'm seeing it more and more, that we're seeing DUI cases on first offenses pleaded down because of this issue. I always scratch my head and I wonder how the hell could somebody be so lucky that they got a first DUI, but somehow it got pleaded down to reckless driving. Well, that happens in the real world. Prosecutors may not want to say it, but it does happen. Law enforcement officers. I know law enforcement officers that will now tell folks they won't cite them for a DUI. They tell them park that car, get somebody to come get you because they don't want to see them be basically ruined in a conviction, no matter whether it's a first, second, third, or subsequent. All of these are blemishes on somebody. But I have a problem with that idea that I don't like to see someone, I'd like to see programs at work. We discussed time and time again the issues of the interlock. Well, you know, interlock is a money bill. You know, they brought this forward for years. As a former governor, used to talk about them folks that stroll around the Capitol in alligator shoes. This is a money bill. This is about moving to that first offense because statistically, a lot of those folks, and yes, a lot of people have already driven under the influence before they get caught. But we've tried to change the conduct of folks. And I don't know how we're changing the conduct by continuing to put the financial penalty on them to the point that these things are getting sympathy. I have no sympathy for someone who gets a DUI. It is what it is. First DUI was a mistake. They made an error. Shame on you. Correct your behavior, because it's not just your life, but it's the life of somebody else that affects it. But once it becomes the sympathy factor, that our judiciary, our law enforcement start feeling that sympathy, that, you know, we want to do something that's not going to just absolutely crucify these folks. You know, I heard a lot of things that was said this today on this, you know, to talk about this interlock device. You know, I really wonder how many indigent folks are there? How many cases are they actually doing this? I don't think there's a whole lot of these. I don't think there's a whole lot of them. This is a money bill, folks. And sometimes creating financial incentives for the companies that produce these things, it isn't getting us what we want. You know, last time this issue was broached a few years ago, I remember we had someone from the judiciary that spoke and told us at that time, and I don't think it's changed since, that judges can already order as a condition an interlock device if they think there's something else. Well, this is carte blanche, just putting it out there. And this is left up to the will of the committee. If you think this is something that's going to help, maybe it will, maybe it won't, but I have my suspicions that it won't help, because it continues to add to this, the legal bureaucracy of these folks. And if you're looking at a first offense right now, you're going to slap them with another $600-800 or whatever for an interlock device. Is it worthy? Does it work? I maintain, and my concerns are that what it's going to do, it continues to push people over that point that they say, I'm not even going to worry about it. I'm going to pay my fine that I got to pay, but I ain't even going to worry about getting the driver's license back. Just a thought for the members to think about.
Thank you, Chairman. Your institutional knowledge is very valuable to this committee.
Chairman Pete, Chairman. And I want to say, want to make a few comments to the chairman, my good friend, who made some great comments, and indeed he has great historical knowledge here of how we've dealt with it. I want to thank you for all you've done over all those many years to improve this issue. And I know I'm going to comment on some of the things you said, but I want you to know I appreciate you, and I appreciate that background. And I appreciate that you're concerned about, we should show compassion. You're right. And we do need to contemplate these things, but I want to mention something to you. So to date, no one in my family has ever received a phone call or any compassion from the man that killed my father by drunk driving. I suspect my good friend, talking about a small world, on this body here, 2 of us lost our fathers to drunk drivers. My friend down at the end of the table here. I doubt you got a phone call either. So here's the thing. So yes, we should show compassion. It sounds to me that in 34 states, all across this union, we've seen, listen, I saw some 40s in your numbers. I mean, we've seen some pretty dramatic impacts. I don't care who's making money. You know, I'm an entrepreneur. I want everybody to make money if they provide a good service. But to the individuals that, like the man that killed my father, who was driving on a suspended license, if there were some way to ensure that they were sober when they got in a car, rather than just trusting that they're gonna not risk driving and get drunk again, because here's what they do. They do it over and over and over and over again. And if you, there's got to be, so I don't know that I follow the logic of not having a route to ensure that if we're going to listen, driving is a privilege. It is not, we have no constitutional right to drive. We have a constitutional right to move about, but not to drive. That's what we all have to follow the law. When you looked at the numbers the chairman mentioned earlier of how many Georgians are dying every year because of the irresponsibility, and to our defense attorney that spoke earlier, I understand, I know what your role is, but here's the thing. $600. So yeah, there's some fines involved. Well, apparently they got enough money to continue to act irresponsibly. And if we don't have consequences for your actions, how do we change people's behaviors? So I just want to say I'm very respectful to my good friend, a man I look up to, his comments and all that. I know how much good work you've done and to deal with DUIs over many years. I thank you for that. But I do believe every time we can make it better, you know, we benefit a multitude of families all across the state. And I support this measure. And I have to tell you, it's hard for me. I hear everybody. It's hard for me to shed a tear over a $600 fee for somebody who's been irresponsible enough to drive on the roads and threaten every man, woman, and child, little babies driving up and down the road. It's hard for me to get real concerned about what they're going to have to pay as a fee to continue to drive in this state when our number one duty as elected officials, nothing more important than protecting the public safety of these people. That's my position.
Thank you, Chair. Number 28 down there. Chairman Jaspers.
Yeah, I just have a practical, just a question on line 885. You know, we talked about, when I was looking through it a couple of days ago, it said that there has to be a provider within 100 miles of me in Jasper. That's in, Mr. Chairman, I just think that's a lot. That's all of North Georgia. You could have one. And if this is to be effective and to be done appropriately, it ought to be much lower and not 50, it should be 50 miles or something that's.
Yeah.
I just think that the 100-mile radius is, it's just too much, and that something in the 50 or whatever this
Chairman Hitchens, you want to comment on that?
Well, I don't think that happens very often. It may not happen at all. There are over 100 providers that install across the state. And my guess is, without knowing exactly, many of them in urban areas, but, I'm from South Georgia, and I think we probably as sparsely populated as anybody in our state. And I know that there are several, I don't think anybody probably has to drive 100 miles. And I know it's an imposition to drive anywhere for anything, but like I think Chairman Petrie says, people put themselves in this position. They do it voluntarily, and they jeopardize everybody else that's on the highway. And you stand out there at 2 o'clock in the morning in the kudzu with dead bodies all around you from somebody that is so intoxicated they can't walk, and they're standing there looking at it too. It gives you a different perspective on what transpires.
Absolutely. Number 25 down here. Who is that? Is that Chairman Powell?
Thank you. And I want to thank the comments from my friend from the coast. And I certainly have no means of apologizing for any drunk driver that hit anyone. But the comments and the take that I'm trying to give for historical perspective is, I don't think anybody is that sympathetic about the money. The money has gotten up so far now. I don't want to make a point about past exploration about these devices. It's a flawed concept in the mind that just by putting a device on that car, that someone who has a problem drinking, that it's going to stop them because they're going to continue to drive in another car. It works on maybe subsequent offenses, but our duty should be to try to create the system that we've created so that those first offenders understand the failure of their conduct, and they go and they sin no more from that. But that's really the point that I'm trying to make. There's no defense to anyone who does this.
And I think the accountability courts have gone a long ways towards doing that. It used to be you go in, pay your fine, and move on. Now, if you obviously have a problem with the accountability courts, they maintain a relationship with you, and there's more rehabilitation involved, and they provide support and counseling. And I think that's gone a long way towards trying to help people who have alcohol problems. We all realize that, and many of these people may not want to drive under the influence. They stop somewhere and they're going to get one beer, and then next thing you know, it's 3 hours later, and they said, I think I can make it all right. and take off. But I think accountability courts have really helped. And I know in my area, they have. Because they just maintain that contact and give support. I mean, you walk out the door and you just start over if otherwise. It's
Any other discussion at this time? Chairman
Question.
Powell.
I might ask the author, I mean, I know the whole debate on this bill has been embroiled about whether a interlock device works or not. But what else is in the bill that actually does help on dealing with these DUI offenders?
most of the rest of this bill is minutia. I mean, it's how you go about doing what you do. I mean, DDS and all the policies and processes, it's most of it's bureaucracy. I mean, it's 30 pages of it, but.
I asked the prosecutor, he's grinning over there, and usually it's fine. When I find lawyers are involved, there's a lot of stuff that ain't necessarily minutia.
No, sir, I wouldn't disagree with that. There's, unfortunately, our provisions related to driver's licenses, the suspensions thereof, getting reinstated, and those kind of things, it's become very voluminous. There are, when you want to make one primary change, sorry if there's difficulty hearing me. If you want to make one primary change to something, you're going to find that there's just a lot of places you have to cross-reference something.
This bill was heard in subcommittee. The subcommittee was on just, okay. Chairman Green.
Thank you, Mr. Chairman. Your subcommittee had under consideration House Bill 439, and as I understand it now, there is a substitute before the full committee, which is LC 393298S, and the subcommittee recommended a do pass.
Okay. Is there a motion do pass?
I make that motion.
Is there a second? Second. Okay, motion made and seconded to pass the substitute to House Bill 439, LC 393298S. All those in favor, say aye.
Aye.
All those opposed? Okay, motion carries. Thank you very much.
I appreciate all your help.
We're here for, sir. Someone else will handle that. Someone else will handle.
We still got the Senate.
If you're able to get to.
Full vote too, so.
See you again. Yeah, have a good one.